So welcome to Washington Arbitration Week first day. And I was unable to attend the inauguration because we have three set of sessions today in different places. So in terms of timeliness and also to make sure that we start at every at the right time, we sort of divided ourselves and conquered. But I would like to relaunch uh, the Washington Arbitration Week. My name is Jose Antonio Rivas. I don't have the pleasure of knowing everyone here, but I know many of you, and we're really glad to launch the sixth Washington Arbitration Week edition. We started as a turn of luck, I would say, during the pandemic. There were many individuals scattered in Washington, D.C. and around the world that wanted to connect. And the pandemic had already gone for about 7 months or so. And people were very enthusiastic about connecting in an online manner. And so we launched Washington Arbitration Week, and we kept at it. And we have smoothly transitioned from a online forum into an in-person forum. Now, all of our panels are in person, and it's really thanks to the support of the audience, and it's really thanks to the support of Washington law firms, but also global law firms and also quantum firms, asset tracers, and especially to an incredible team of WOW, including some of whom are here and some of whom are online, especially our moderator today, María Matamala, and Moment, but also in general terms, the international arbitration community. And we have two objectives. One is really to bring the notion of international arbitration, which is a dispute settlement um, mechanism, beyond beyond our borders, and certainly beyond the international arbitration community. We sort of renege from only welcoming the communities that is already convinced, and that's why Washington Arbitration Week is completely free of cost for in-person attendees and also for individuals connecting to us uh, online. And the other one is really bringing the latest topics, and we go through a very organic process through our um, advisory committee, but also we try to hear every potential or every person who is part of the International Arbitration Week or International Arbitration Community, including students, academics, arbitrators, counsel, individuals who work in a position in international organizations, in the State Department, in other defense teams of other sovereign states, etc. And we listen and we try to bring what is new, and sometimes, yes, what is a little bit controversial, but in order to be transparent and in order to learn. With that, welcome, and and I would like to introduce María Matamala. Today's uh, topic is one of the topics is regional update on regulations in the Americas with potential impact in investment disputes. Maria, in addition to being the project manager of Washington Arbitration Week and also the World Arbitration Update, she is a associate at Xtrategy, our boutique law firm here in Washington, D.C., and also with presence in Colombia. And she is a lawyer and a political scientist from Universidad de los Andes in Colombia. She's barred in Colombia, and she focuses on public international law, international investment arbitration, and corporate law. She's an associate here, advising on complex investment and commercial arbitrations involving sovereign states and supporting cross-jurisdictional regulatory matters. She also leads the development of Washington Arbitration Week, as I have shared with you. I would like to say also, in addition to saying thanks to her, she has a very very specific gift for detail. If you're not detailed, this wouldn't be happening. I promise that. So with that, Maria, take it away.
Well, thank you, Antonio, and welcome everyone. Welcome to my panelist as well. This is panel 3 on day 1 of Washington Arbitration Week. We're seeing that Latin America is in the midst of a profound transformation. We see across the region that there are new regulatory frameworks happening in a variety of different sectors. And as we will see, those sectors are seeing also affects to investments. Together, the 4 panelists will guide us through the evolving and uncertain landscapes, industry-specific risk, and broader dynamics driving arbitration across the Americas. You will hear perspectives on the energy transition, on oil and gas, disputes, environmental regulation, and key industry trends in countries such as Mexico, Colombia, Peru, and Costa Rica, among others. With that, I have the immense pleasure of presenting each of my panelists. I will start with Chris Polson. Chris Polson is a partner with PricewaterhouseCoopers LLP and leads the dispute advisory practice. Chris has over 30 years of experience in business valuation, damage quantification, disputes, investigations, and expert testimony. He has been retained on numerous matters where the loss quantum has ranged into the billions of dollars and is recommended by Xtrategy as a top arbitration expert and commercial litigation expert. His past assignments have encompassed a wide range of industries, including financial services, technology, pharmaceuticals, manufacturing, transportation, natural resources, real estate, construction, retail, and sport franchises. Chris also acts as a neutral arbitrator in commercial disputes and has provided financial advisory services in connection with corporate transactions. Now we have with us Adriana Espinel. Adriana is a Colombian attorney specializing in energy law, arbitration, and regulatory frameworks for the energy transition in Latin America. She's of counsel at Xtrategy, arbitrator, professor of energy law, and an active member of the Asociación Colombiana del Hidrógeno. Adriana has advised governments, private investors, and multilateral organizations on electricity and hydrogen regulation across the region. We also have with us Fabio Núñez. Fabio is a lawyer, graduated from the Pontifical Catholic University of Peru. He holds an LLM from Yale Law School and is currently pursuing a PhD at the University of Oxford. He is admitted to practice law in Peru and New York and is a solicitor of England and Wales. He is also a special counsel consultant, special legal consultant in Washington, D.C. Fabio is a professor at the Pontifical Catholic University of Peru and a partner at Rebaza, Alcázar y de las Casas. And lastly, we have Eduardo Mathison. Eduardo is a counsel in Crowell and Moore's International Dispute Resolution Group and is based in the Washington, D.C. office. He concentrates his practice on international arbitration and litigation matters across various industries and jurisdictions. He's also an active member of Crowell's Latin American practice, where he has assisted clients and worked with local counsel in more than a dozen jurisdictions across Latin America on a wide range of matters. Eduardo holds an LLM from Georgetown University Law Center and is qualified in the District of Columbia, New York, and Venezuela. So with that amazing presentation of our panelists today, I wanted to start by asking each of you the following question, and is, what trends do you see across the Americas in terms of regulatory shifts impacting foreign investment? So, Adriana.
Thank you, Maria. Thank you, Jose Antonio, for the invitation and for all of you that are attending this panel. Okay, for me, the most important thing is that in Latin America, we are challenged a change between liberalization and state control. Some of our countries, as Colombia, Mexico, and Chile, also Brazil in different ways, and Peru on different ways as well, are changing the rules from liberalization and to control of the states in regulation. In the energy sector, we saw that specifically going through uncertainty regulations regarding energy markets and the difference between these liberalization markets. So this tension drives in an unpredictable certainty in regulations. We have also problems with the rules and in environmental laws, and also the rules which we manage the problems with community, indigenous and ethnical communities. So these tensions are creating some tension between the investors and the states, and also for example, in Colombia, there are a lot of companies that are leaving the country because this type of problems. For example, environmental regulatory rules that are changing and growing up in a different ways, and also the changes or the difficulties with the arrangements with communities are creating a lot of problems for investors. So I think that it is necessary to intend to stabilize that goal and that different rules. And for example, for investments, the most important thing is the stabilization of the rules, to understand how the rules are, how the political framework are, and how are the countries putting out that on context. So it is important to stabilize clauses, try to put it in the agreements and the PPAs, for example, in energy contracts. Also prevent the tariff adjustment that are changing a lot in our countries. So we have to prevent it in the contracts in order to prevent disputes, and also take into advance how social license and environmental license are creating difficulties in order to prevent it in the contracts, and to create a stability or a structure of volatility. And for government, it is important to focus in security and transparency, creating clear roadmaps, and also a consultation with the ethical and with ethnical, and indigenous groups. Also to create rule-based auctions in the energy acquisitions and energy trade, and also create a very clear rule and transparent way to do the things in environmental way. In short, Latin America is not closing to have this market solutions in a pacific way. So, and that is a specific thing that is happening, and is that the world needs a lot of energy. So we in Latin America have the resources, but we are facing different changes in political, environmental. So that makes it the things very difficult, because regulatory framework is going low against the way that rapidly are growing in, for example, energy markets, because we need a lot of energy. We are not prepared inside our countries, and the regulation is going slow. So for that reason, it's not matching the rules. So it is necessary to understand that. And also, as just to finish my intervention, it is important to understand that we are now facing we need to change our system in energy to distributed system, generate distributed energy system, in order to challenge the changes of the world. And that means that in Latin America, we are facing a lot of changes, regulatory changes, that governments need to understand and adapt easily and quicker. And for investors, they also need to understand how it's going to grow and how it's going to at the end, we're created that kind of framework.
Thank you, Adriana. Fabio, now with you, what trends are you seeing across the Americas?
Thank you. Thank you very much. Thank you also to the,
Turn on your microphone.
sorry about that. Thank you to the Washington Arbitration Week, and specifically to Jose Antonio and Maria for the kind invitation and the amazing organization. Regarding the question, I don't think there is a uniform trend. I think that regarding regulatory shifts, these are highly country specific and context dependent. What I see, however, is a trend in specific countries like Mexico, Chile, Bolivia, that are tightening their regulations in a specific extractive sectors and also regarding environmental matters. For example, creating new mining laws that happened in Mexico last year, or maybe announcing the creation of state-owned corporations. Gabriel Boric has recently announced the creation of a lithium state corporation, or recognizing more rights of indigenous people. So that's happening a lot. We'll talk a little bit about this in a while. What I see also is that there will be more investment disputes in the future. There is an easy answer for this. There are more bids, there are more instruments. Nowadays, investors are more conscious. They negotiate better their contracts. They do not only rely on investment protection, also on contractual protection, include the stabilization clauses. So, but on the other side, 1 decade ago, states, I think they were more like, there was like a chilling effect. Today, they are more conscious of their duty to regulate in order to ensure the public welfare. And that's happening a lot. They also rely on third generation treaties. So I think that's there will be more investment disputes. We'll also talk a little bit about this. And lastly, the last point I want to raise is that I think that nowadays investors should take into account when investing in the region, specifically in Latin America, they should take into account another considerations. Firstly, I think that due diligence should not be seen as a legal matter. It should not only be a legal due diligence, it should also be geopolitical. It's about understanding politically, economically, even socially the country. And also what I was talking, investors are already doing this, but secondly, I think it's important that investors should not only rely on investments, on bids. It's very important to negotiate very well your contracts. You know, you now see it's very difficult to prevail in a treaty case. It's a little bit easier to prevail on a contractual case. So it's a very good idea not only to ensure treaty protection, but to negotiate very well your contract. You know, a very strong dispute settlement clause, stabilization clauses, you know, and now you have these investment treaties in which you do not only rely on a treaty or a contract, you rely on both. Some of these cases, it's easier to prevail, like Kunturwasi case and several others. So those are my 2 cents on the question. Thank you.
Thank you, Fabio. Chris?
We have more in common than I would have guessed, actually. I've been asked to speak on behalf of the neighbors to the north, and as you can imagine, there is a lot going on with respect to the trade relationship between Canada and the US over the last several months. It's the world's largest trading relationship, $3 billion a day, $1 trillion a year, pretty evenly balanced. But speaking as a partner at PwC, almost all of our corporate clients have put a complete hiatus on any kind of capital spend or investment over the last 6 months. It's pretty, we're looking forward to what's called a review of the USMCA, which I think is 6 to 9 months away. But the general consensus is that that's going to give us any kind of confidence or security. It'll continue to be an evolving issue, which is not great for foreign investment. We had incredibly low corporate investment and deal activity for 6 months. And interestingly, what we've just seen coming out of the summer is probably our busiest 3 months of deal activity, where M&A took off like a rocket towards the end of the summer. And speaking to clients, the general consensus there is we don't know what's coming, but we know it's going to be a business-friendly administration, and we expect interest rates to be low for the foreseeable future, and we might as well get on with it.
Thank you, Chris. Eduardo, would you like or?
I think I'll leave my comments for
Perfect. So Adriana, I wanted to start with you with this segment in energy regulation and also hydrogen markets in Latin America. And I think my question for you will be, how can Latin American countries strike the right balance between ensuring energy security and attracting new investments in renewables and hydrogen?
Well, in Latin America, it depends on the source of energy we have. For example, in Colombia, we have a lot of renewables, and that's the most important energy source. So we are hydro. At the present moment, our mix energy market is component by hydro, 70%, and the other part of the matrix is thermoelectrical and also renewables. Renewables we are growing up, so it's not a consolidated market. So it depends on, for example, in Brazil, they have a lot of bio combustibles. No, but not only biodiesel, they have biofuels. So that is an important market for them, and there are focuses on that. And all the transition or the energy transition is focused on that. And then, for example, in Peru, you are focusing on mining, and also in Mexico, they are focusing in oil and gas. So it depends, no? But I think that for everybody, for all the countries, we need predictable rules. What is happening in our countries is that there is a changing very fast, the regulation, and it is very close to the political decisions. So it makes a lot of uncertainty for the investors. And of course, they create a lot of dispute at the end. They are changing rules, specifically in environmental matters and in tariffs. So we are changing the rules. So because of that, we are creating a lot of disputes. So the most important thing is to create predictable rules. The second thing is to create strong grids and strong in order to create a strong energy markets, because we are having a lot of problems with infrastructure, a lot of problems with the change between the fast change between hydrocarbons, fuels to clean energy, and that is creating a lot of gaps and uncertainty for investors. And also not only that, but also creating a lot of problems in the energy market, because countries as Colombia, for example, we need fuels in order to fight against the climate change. You cannot depend only in hydro or in renewables. We also need to face these changes with fuels, but our government is saying not, and a strong not to fuels or to oil, and that is creating a huge gap in the fiscal and economy, and also with a lot of possibility of turn off our energy market. So that kind of things is necessary to understand and to try to figure out. A lot of companies are international companies, for example, in Colombia, are leaving the country because of that. So we need to create more infrastructure, solid infrastructure, to create solid regulation in tariffs, and also to create rules, certain rules in environmental markets, and also try to manage the situation with communities. Because as I said at the beginning, the problems that we face with communities, indigenous and ethical communities, the problem is that we cannot make good agreements with them. So the government needs to rule a better role on that, creating dispute resolution with them, and also create a better negotiator role with them. If the rules are stable, the investment of the private sector is going to go to our countries, because we need the money to create that kind of to grow the energy markets. So the governments are facing that position that is very political against, or at the same time, we need the private capital to run our market. Otherwise, we are going to face the problems that we're facing in Colombia, for example, and it is possible to have the same thing in Mexico, because in Mexico they are open the market, but they are putting a lot of rules with a strong focus on a public company. So the public companies are going to have the manage of the regulation, and that's going to have a lot of problems also there. So we need to take care. But as you said at the beginning, it is very important to understand our countries, the policy of our countries, and the story of our policy. Not only what is happening now, but also what is happening in the past. Because in our countries in Latin America, we really are what we do, not what is put in the law. So we need to know the past. We need to know the history of our relation in order to understand. And another thing is that we are a very huge source of energy. But that kind of things, of course, can create a lot of dispute in the future, as you said, because today we are facing this growing very fast of the market with technology, and also with the world need of a lot of energy, especially data centers and with AA. So this is going to be a very challenge for us and for the market as well. Also, and just to close the question is, government must work close with private sector. Is the only way to go from this kind of markets to the one that we are facing today, with the AA data centers and all the energy that the world is going to need. So that's the balance scheme.
Thank you, Adriana. I want to move a little bit towards the north and ask Chris, what type of regulatory activities, are you currently seeing in Canada? And how does arbitration vary depending on the nature of the regulation?
Can I ask a follow-up question to the last comment before I move on?
Of course. Please go ahead.
One of our largest clients is Brookfield, which is involved in, it's a private investor involved in renewable energy space largely. And they are struggling to put capital to play because of the instability and uncertainty associated with energy strategy around the world. Are you familiar with how governments deal with private investors and what assurances, if any, they can provide in return for that investment? Because that seems like a source of dispute, potentially.
Yes, I think so. For example, blockchain is going to buy AAS, and that's public.
Yeah.
Because that kind of funds now or needs money to invest in data centers. So they know that Latin America have a lot of resources in renewables, solar and wind. And we have a huge potential. The thing is that the rules are, as I said, uncertain. So what is the thing? The thing is, for example, countries as Colombia, it looks like they are going slow, because we are growing in our regulatory framework to distributing energy. So that helps to understand and to grow very fast a market as renewables. But we are facing problems with infrastructure, so we need to do that. And it is possible to do that not only with public investment, but also with that kind of investment. For example, with data center, we can create a very interesting market that help to invest in private infrastructure. The problem is that now we are facing that kind of warranties, for example. What guarantees are we facing? So in renewables, the best way to do that is of the project that they can invest on. I mean, if you want, if the funds are asking for very strong projects with not only a due diligence, a very good due diligence in the way that are doing the business, but also in the PPAs they have to put the energy with. So that we need strong PPAs. And that's a thing in Latin America. You know, the demand is something that you have to look very carefully. And also the regulation possibility to do flexible the market. In what I mean, it means that in distribution energy, you need to have the play of the consumers as a pro-consumers. So not only to consume the energy, but also to be capable to negotiate that energy with third parties. And for that reason, it's also important that the communities, indigenous and ethnic communities, make part of that project as shareholders. So that is also very important. That kind of things create an environmental of security uncertainty, some certainly, to that kind of investments. But also we have to work on, as I said, certainly in regulations, because Mexico is changing a lot in different things, and they can put now the rules very clear, and it will be very, very difficult and that's the best way to get into a dispute, you know, to have these kind of things. I don't know if I answered your question with my...
you raised a bunch of other questions, but that's fine. I'll just make a quick comment and then I'll hand it off. I wonder what we've learned from the arbitrations in Spain a couple of years ago, right? All the renewable energy and how that went sideways. Another one of our largest, probably our largest client is Microsoft, and they've been negotiating for their data centers around the world, trying to find a reliable source of energy to power those data centers. And due to an inability to predict what energy strategy was going to look like down the road, they've now become the largest buyer of small modular reactors in the US. Like they've decided basically just to completely privatize their entire power supply. And that's it's not an option available to everyone, but it's interesting that it got there through a risk analysis.
Yes. Fabio, I wanted to move to you. So considering Peru and also the rest of the region, in which economic sector do you think investment arbitrations will substantially increase in the next decade?
Thank you. Thank you for the question, Maria. I mean, probably we all know that the pivotal role that energy and oil and gas comply nowadays, but I would like to put on the spotlight another sector which is extremely important, and I would think that in this sector there will be many investment disputes in the near future, which is mining. This is because many reasons. One of those reasons is the energy transition. If you see the prices of minerals right now, they are extremely high, and if you see the statistics, they will remain stable like that for the next 10 or 15 years. There will be a lot of scarcity, and the scarcity always creates conflicts. And the rationality is pretty simple, you know, because if you want to create an electric car, for example, you need 4 times the amount of copper that you need is 4 times the ones that you need for a conventional car. And if you want to create a turbine wind, you need tons of copper and silver. So yeah, the prices will be extremely high. And that will create a lot of investment disputes. Now, the other issue is that mining is an extremely conflictive industry. So I think that this scarcity plus the fact that this is very conflictive will create a lot of investment disputes. I'm seeing this right now, and it seemed interesting to analyze this from a theoretical glance and see it in practice. A couple of weeks ago, we were engaged by an important client mining company. And it's interesting because the case was a commercial case. It was pretty straightforward, but the counterparty breached the contract. And we proposed them, well, let's ask for damages. And they told us, we don't want damages. We want the minerals. Let's ask for a specific performance. Why? Because of the scarcity. So you see these economic problems having an impact on reality. So what kinds of disputes we will see in the future? And what is interesting is it is not the future. This is already happening. If you see ICSID statistics from 2025, from January to July, you'll see the mining is in the first place with infrastructure. So it's very interesting to understand the reasons. What kinds of disputes? Disputes because the state increased mining taxes or royalties. That's happening in Chile right now. They have recently created a law creating a mining royalty. Probably you're acquainted with Freeport and Cerro Verde cases in Peru, also related to royalties. Also, other controversies such as revocating environmental regulations. This happened a couple of days ago in Ecuador. In the Loma Larga Gold Project, the environmental license was revoked. Also, many states will want to have a participation in corporations. This is happening again. Why is this happening? Because they want to have their size. They want to have the take. They want to take decisions in these companies. This happened also in Ecuador, Codelco versus Ecuador. And again, this is very conflictive industry. So you have a lot of investment disputes that involve indigenous communities. And regarding this, I think that my country is especially relevant, Peru. You're acquainted probably with cases like Bear Creek or Peru Petro versus Plus Petrol, in which I acted as counsel, a lot of protests. Or, I don't know, Lupaca, that was actually, the word was rendered like, I don't know, a month ago. So there is a lot of room regarding these controversies for full and protection and security claims also. So yeah, there is a lot for mining. The other small point that I want to raise, maybe to share a little bit about my country, and that this is the last point, is that mega project in Peru is the Megaport of Chancay. And you already see a lot of investment disputes there that are, but why? Because this is not only a project in Peru, it's for Latin America. It's the entrance door of China to Peru. It is administered by COSCO Shipping. And this has been, started operating like months ago, and already 2 potential investment disputes in just months. So one, because the Peruvian state wanted to revoke the exclusivity of COSCO. COSCO invested $3,200 million in order to have that exclusivity. And intempestively, they wanted to revoke the exclusivity. Now, that matter is like, the state is acting intelligently, but now in the copy, which is the antitrust authority, is imposing tariffs because it is arguing that it is a natural monopoly and it should impose tariffs. COSCO argues that it's unfair and is going to launch several legal actions. So yeah, of course, mining and infrastructure, because of the infrastructure gap that exists in Peru and in Latin America in general, are going to be the 2 of the most important sectors. So yeah, that's my take on this question.
Thank you, Fabio. Really interesting. Chris, what trends are we also seeing in Canada?
I gotta defer to Eduardo. He's good-looking guy over here. He's with the chance to. I'll take a break and I'll come back after. Sorry, do you pose the question?
Yes, I thought you wanted to comment. Eduardo, also considering some of the cases and how we're seeing tribunals act, what are some of the key trends you see in recent fair and equitable treatment decisions, particularly those that are involving environmental regulations?
Thanks, Maria. I also want to thank you, Jose Antonio, the whole Washington Arbitration Week team for inviting me. It's really an honor to be part of this conference once again. Thank you everyone for attending. To your question, Maria, and I'm going to mention briefly a little bit of some of my co-panelists' takes as well. Actually, I'm going to start not with a trend, but more with a disclaimer, more of a disclaimer based on standard practice that, you know, in the context of environmental protection or otherwise, I mean, these cases, I mean, they will always be very highly fact specific. That's going to continue to be the case. And tribunals, I mean, they have a task, and they have their task to assess a case based on the facts, the evidence, the arguments presented by the party. That is not going to change. That means we're going to continue to have mixed results. Now, moving to trends. There are a couple of things that I want to talk about. First of all, is on legitimate expectations. That I think it goes to some of the points that my co-panelists have made. I think, at least in some contexts, my take is that the scope of legitimate expectations appears to be narrowing. I think tribunals tend to protect investors only when there have been clear, specific promises or incentives or assurances. So, like what Fabio was talking about, like it be either contractual guarantees or like written promises, as opposed to it's going to be more challenging for investors when you're trying to challenge is a regulatory framework and not a very specific, clear assurance or promise that was made to a foreign investor. That doesn't necessarily mean that our tribunals are increasingly siding with states. On the European solar cases that Chris was mentioning, actually, I've seen, at least in the past couple of years, I've seen a bit of everything. I've seen cases where tribunals have found breaches of FET, where like certain incentive regimes were like taken away or altered retroactively. I've also seen tribunals that have upheld the state's right to regulate when the investors' expectations were not grounded on like a very explicit, specific assurances. So that's that. So now that I mentioned the right to regulate, that's a second trend that I want to talk about. And that is something that I'm just seeing a growing recognition of the state's sovereign right to regulate in treaty practice in general. We're starting to see states to including explicit right to regulate clauses or language in general in their bilateral investment treaties. There's a recent stat in a report by UNCTAD that says that over 70% of the IAA signed between 2020 and 2023, over 70% of them had a right to regulate clause. So I thought that was interesting. And typically what this type of clause or language, what it's intended to do is to generally limit the investor's expectations by basically specifying that or making clear that any regulatory measures or changes by any government that are made for public policy purposes, they do not by themselves constitute a breach of a treaty obligation. So you will have to that would put the investor in a position that they'll have to look for something else. In the perfect example is in India, I would say, is the 2015 model, PAT model. They've been leading this trend, and in the Americas, a good example of it is India, Brazil, VAT. It doesn't have a specific laws like we've seen in other bilateral investment treaties, but it does, in the preamble, it does reaffirm the right of the parties to regulate investments in their territory in accordance with their laws and policy objectives. Maybe not as strong as a provision, but I mean, you're starting to see that type of language in investment treaties. I know you have a couple of follow-up questions on the right to regulate, so maybe I'll stop here.
Yes, I was wondering how are arbitral tribunals balancing the state's right to regulate with investor protections?
Yeah. So yeah, I mean, tribunals are always going to try to balance between regulatory autonomy and investor protection. That said, in my view, I think tribunals, they tend to defer to states and their sovereign right to regulate, especially when it's a close call. But of course, as I mentioned at the beginning, this is like highly based on the facts. So tribunals are still going to scrutinize if a state's conduct is arbitrary or discriminatory or disproportionate, or if there are any specific commitments that were made to investors that have been taken away. That is still something that tribunals are going to look into. But so I think in general, the threshold for finding a breach of FET, I think it's still more or less the same. But of course, it will depend on the language of the treaty. So if a treaty includes a right to regulate clause, I expect that anytime that any regulatory changes are being challenged, that's gonna give a harder time to tribunals, so that potentially means that it will be less likely for investors to have a successful claim, or at least it will probably, I mean, it's something that tribunals will definitely be more careful in the decision-making process. And let me just jump to my expectation in the long term. I think I take Fabio's point. I also think that we're coming to this trend where cases may be more predictable, but also more. I'm expecting a more constrained investment dispute climate. I think investors are going to start facing higher barriers when challenging regulatory changes. But again, this doesn't give full immunity to governments, and especially in the region. Some of the examples that I've heard today, we are going to continue to see, maybe it used to be in Latin America, but probably now it's across the whole hemisphere. We're going to continue to see government offices exceeding their authority, or politicians making mistakes. And that could always lead to a claim that eventually, an arbitral tribunal finding state conduct to be arbitrary or irrational or discriminatory. So yeah, I mean, to close, one more thing on point that Fabio made. I totally agree. Investors, I think I'm expecting investors to conduct even more thorough due diligence, and to seek specific commitments based on the case law, the precedents that we've seen in the next couple of years. That's a wake-up call for investors. So that's something that some protections that should definitely need to look into. And ultimately, I mean, I would say not only in the region, but more globally, I think governments are moving to toward establishing higher thresholds for investor claims, either on jurisdiction or on substantive claims. So it'll remain to, I mean, we'll see if that will discourage investment or investment disputes or not. I would expect at least more predictable outcomes.
Any of the panelists want to comment?
I disagree.
I knew that. It's controversial.
Yeah, let's have a debate about it. I mean, we see, broadly speaking, two flavors of regulatory dispute. There's environmental and social disputes, which, touch on right to regulate for sure. And then we're increasingly seeing economic security and sovereignty, which is another thing altogether. And those pivot around key resources in which no nation, to my knowledge, is an island. You've got technology, you've got energy, you've got materials, mining, and I would argue capital is another resource of those four. And speaking for Canada, we certainly need friends and allies to help round out those four, and I think that's true of every nation. But I do see blocks forming, and I could see that being the case over the next 10 or 20 years, where different geopolitical blocks that constitute all four of those resources align with each other. And then how do you resolve disputes amongst your friends and family? And then how do you resolve disputes amongst a hostile bloc? And I don't know what that's going to look like. I wouldn't say it's going to be easy.
Yeah, I think that's a fair point.
It's not fair to go out 20 years and ask.
But yeah, I mean, I would say that I mean, have we seen the how investment, the treaty practice has evolved over the last couple of decades? I mean, yeah, I mean, if you look at the treaties, the standard, the model treaty in the 90s, I mean, if you look at the language, that's always because lawyers always make things more complicated than they were.
It can always be improved.
It can always be improved. If you look at a standard treaty from the 90s, I mean, they had pretty short, straightforward FET, national treatment, MFN provisions, really straightforward dispute settlement clauses. Now they're getting longer and longer, even in some cases like India, again, they're dropping the term fair and equitable treatment. So they're trying to, I mean, they're defining what a violation of fair and equitable treatment would be, but they're not actually saying those words, because they fear that tribunals might oversee that they're going to ignore the language of the treaty, and they're going to say, "No, this is fair and equal treatment." Let me look at this 20, 30 cases a year that we're having in average. So yeah, I think it's just governments are getting smarter at these, but it's always a constant race.
Well, continuing with Chris, I wanted to redo the question also, as you have spoken about the sectors, and is what are the industries that are being most impacted by this increased regulatory intervention? Also considering those changes that have been in energy and in mining, also from the Canada perspective.
Thanks. Yeah, I would go back to the core four, I guess. The technology, materials, energy, and capital are, we're seeing some really interesting developments in all four of those. And it doesn't always take the form that you would think. It's not always necessarily a tariff or some sort of tax or oppressive regulation. One of the dynamics we have right now that I'm watching, and I find it really, really interesting, is rare earths, for instance, which are becoming increasingly strategically important. And as you probably know, most rare earths, the vast majority of them, come out of China right now. And the West doesn't have any productive capacity in any significant way to respond to that critical resource. Canada does have some up north, and there was an interest from Chinese investors in building mines up there, which was blocked because of who the investors were. There have been forays into developing those rare earths, but what's transpired is that anytime there's a serious effort to open those mines and develop another productive resource, China drops the price and opens the floodgates. And so the market says, why would we build this billion or trillion dollar resource when it seems as though everything's fine? And I mean, it's analogous in some ways, I think, to what's going on with NVIDIA and their chips, where their first generation, China is eager to develop competing capacity, but they're never going to do so until they are so far behind that it's absolutely necessary. Like they're getting second or third generation chips right now, which is enough to function, but not enough for strategic superiority. To develop best in class microprocessor capability would be an enormous undertaking. And I think just as China is doing with its rare earths, the US is doing something similar in response to saying, here's a little bit, but not quite enough.
Yeah, I'm seeing that the semiconductor industry also relies upon mining in the rest of the region, specifically Chile. So that's also why in Chile we're seeing that new regulations are trying that the process for investors in the mining sector are faster.
Yeah.
Because we need the supply to keep on going, right?
And massive amounts of capital. Like it's all linked together to some degree too.
Well, I don't know if any of you have any comments to what Chris has said. I know I had a question for Adriana with the hydrogen market. I don't know if we've seen, I know in Colombia and in some of the others neighboring countries, but for example, with Costa Rica, with Mexico, what is happening with the hydrogen market?
So the hydrogen market is a new market in all over the world and also in Latin America. And we challenge a lot of important things to take care of. The first one is related to the definition of hydrogen. Is not because of the color or because of the decarbonization process. So it is very important because it is depending on the phase of the government is looking for. For example, if they're looking only for decarbonization the industry or have putting into the market fuels, and if you have carbon capture, it will be very, very important for that kind of stuff in the United States, for example. But if you are talking about renewables at Costa Rica, we are focusing on hydrogen and green hydrogen, on all the policy regarding that. So it depends on the type of energy sources and the political decision that you are. But so that is important. Also, it is very important to focus on security and quality, and that is a challenge. We have to put all the countries in the same position as working with international standards and looking forward, because now we know that security is something that we have to work and we have the tools to do it. But in talking about quality, we are just trying to figure out how it works. So the regulation is coming slowly and with some important developments on that. The third thing is certification. Certification of hydrogen is very important for the international markets and to put all the countries in this international play, like all work together. European countries need hydrogen. So, and they are, of course, as Asia and Australia, the buyers of the hydrogen. So in Latin America, we have to work very hard, very closely to the requirements of certification in hydrogen to go with that requirement. And as Chris says, it is important to understand that now this is a global market. No, we are not talking about one country, another country, what region. This is a global thing. And if we need to change the transition of energy, we must think like that. And that's why I think that one important thing is that we are walking through the way that regulation is recalibrated in all the countries, not in the expropriation, talking about arbitration. Because now, with these global markets, we are growing up very, very faster. So all the countries need to do adjustment in regulation, and this is going to be like all day, no? All years they are going to change, and that is going to be the for me the main source of disputes in our region. One, then I come back to hydrogen. Other thing is we need buyers. So in Latin America, we need to buy to work in incentive, of course, in the United States as well, to buyers. Buyers are very important. We have a lot of work in all the regulation for incentives in the production of hydrogen, but not in the demand. So we must focus on that. And that is very important to our market in hydrogen. Also, we need in Latin America money. As you say, capital is something very important. So we need that capital. And we have cases of Brazil that they have a lot of money, they put money on the market, and they can work with public funds and also with international funds, but countries as Colombia, as Peru, as Costa Rica, they can't. So we need to focus on a strategy to understand how to build a very strong financial system, as for example, they're working in Chile. So they are putting together the public investors, private investors, and also the international cooperation funds to put it together and to try to work with the projects. Because in hydrogen, we need projects, not only just a theoretical thing, but projects in Europe, in Asia, in Australia, they are working on projects. They need the hydrogen. So we need to do the same here in Latin America. And talking about America, what I saw is that they started to create a very important market in the past government with green hydrogen. But now they're going to the blue hydrogen that is with gas. Because we need all type of energy. So I think that that's a great thing for hydrogen. Hydrogen could be produced with a lot of sources of energy. And in that moment, we need to just focus on what to do that, always focusing in the decarbonization. So use carbon capture. So in that way, hydrogen is going, they are facing that type of challenge. I don't know if I missed something, but I think that everything
covered it.
I covered everything.
Really interesting about hydrogen. I want to see if any of the other panelists have any closing remarks they want to make. I would like to open the floor to any questions we have.
Just to follow on from that point, it'll be interesting to see if there is an integration of regulation amongst friendly nations. I think that's essential if you're going to trade freely with each other. And it's, certainly speaking between Canada and the US, there's been a great deal of integration there. But with that comes a loss of sovereignty and autonomy over the regulatory behavior, right?
Right.
And that tension will be something interesting to watch. You're connected at the hip to each other by necessity.
Yeah.
But then you lose a little bit of your independence at the same time for economic and political security.
Yeah, that's true. I think in that now we depend on political positions. Like the United States is going to put in a lot of, for example, in tariffs.
Yeah.
So that will be complicated. But at the end, I think that the world have to be in a global, for a global market. And also what you're talking about is auto-regulation. Self-regulation. I think we are going to self-regulation. I'm talking about 20 years ahead, not now, but yes. So that's why I put effort. I put my focus on distributed energy, energía distribuida, because that's the way that that's the way that countries will face this energy necessity that we have. And in that kind of markets, we are going to grow all as a global entity, trying to put all the rules on the table for everyone. That's my that's what I think. So for that reason, I think, and I said that regulatory is going to change like rapidly, and trying to figure out how to put it together with all the technology, with all the energy the world needs, with all the problems that we need. And problem like the United States is going to change rapidly, accordingly with economy and accordingly with business. So that kind of changes are going to be the arbitration dispute in the future, because we are going to face changes that probably are not going to be fair at the beginning, until we arrive to that kind of market. That's what I think.
Thank you, Adriana. I don't know if anyone from the audience wants to, or from Zoom as well, have a question. Just
I can speak out loud. Don't worry.
Okay. And so, the thing is, if you speak out loud, people will not hear you. Zoom. Even if you speak out loud, you need a microphone so people can hear your question.
Yeah. Thank you very much for the panelists that raise a lot of similar issue like with the Asia, because like with the investment dispute, we have a lot of issue with the let's say the energy dispute as well, mining and also like mineral. And we face the issue with like state-owned enterprise dominant on those area. But for example, it's like if from your side at the country, so it's like you have like the state-owned enterprise contract with the other side. So, and if the other side is like, so for example, Canada or the US, it's very easy to prove that is the investor and the state dispute. But for like, let's say China, like China do investment in Chile or Colombia. So China's, we have to distinguish whether the China is the China at the country or the China at the corporation. So to that extent, we have to distinguish whether the function, like the governmental function, or let's say that is like the commercial function. So I would like the panelists, if possible, share some experience. What is the hint or what is the key factor we have to consider when we distinguish that is the state versus state, or the state versus the investor. So that is the question I would like to ask. Thank you.
Well, what I think first I want to understand if I want to see if I understand well the question. So you are thinking about China as a country and China as a corporation, as China's corporation working in our countries. That's right?
They have two scenarios because like it's very tough to distinguish the China enterprise doing investment in Africa or doing investment in America. That is the state entity, or it is a private entity. So it's go to the detail, because like the China, they do, because at the end of the day, the government control kind of not everything, but significantly the government control. So I'm very concerned, if possible, like how to distinguish the government function and the commercial function.
Maybe just one quick comment, and sorry, I'm not answering or addressing your question by this, but just want to point out that in some investment treaties, actually the definition of investor that could include either private or state-owned enterprises. We've seen it in, for example, in the Gulf, in the Middle East. There are most foreign investors coming from the area. They have a strong component of state involvement. So that's very common there. Also like NAFTA, that you could be a state-owned entity and still bring an investment claim and just be a party to a dispute. I don't know if that at least partially answers your question, but that could, it depends on the treaty.
For me, it is very difficult to differentiate China as a government and China as an entrepreneur. I'm talking about my own experience because theoretically it is very easy. But there is China investment everywhere. This in my country, you have no idea, like energy, construction, it's everywhere. And that's great. But I remember once I had a case with China railroads, China railroads tunnel, and then China railroads number 10. And one was our client, the other was the counterparty. We had no idea if we could actually accept the case, so we made our research. All of these companies, most of them are from the government, but then we asked and they were completely disconnected. They had nothing to do with each other. They had the same name, and that happens a lot with China. They are from the government, but they are at the same time investors, So it is very difficult. But there is, I think, a bias that China is having so much influence in Latin America for many people. That's not my point of view. I think it's doing great things, what it's doing with the mega port of Chancay. My law firm was counsel of the biggest M&A last year in Enel Group. So I think it's amazing, but it's true. It is very difficult to differentiate China because at the same time, it is actually the roots are on the government. But yeah.
And none of us want to lose access to TikTok either. So I think, it is really difficult to make that delineation. One of the things I think you would reasonably look to is the court systems in the country and the degree to which private enterprise truly does operate independently and is protected. Their interests are protected against the interests of public enterprise when they're in conflict with each other. It's one thing to have that legislation on the books. I think it's another thing entirely to see it enforced in practice. And I think if you had a good track record of that, you get greater comfort.
I know we have Chris as well.
Thank you. Chris Goncalves with the RG Energy and Climate Practice, coming from the expert perspective. I want to posit sort of a global trend and then ask about a different distinction, which is the one that was discussed earlier the distinction between the change in regulation or the right to regulate provisions of newer BITs with the issue of change in policy and where you draw the line. So the macro trend is not just invented in the United States, but this pendulum swing between sustainability and climate forward policies and energy security and affordability policies on the other hand. And it's obviously very extreme here in the US right now, but it's going on all over the world. It's going on in Europe, it's going on in Latin America, Southeast Asia, and so forth. And governments are making very important policy decisions for public service reasons about going one direction or the other. Just within this panel, we can see several of those policies moving a lot within the last period of years. So where, from a lawyer's perspective, where do you draw, and from an investor state claim perspective, where do you draw the line, if you can draw a line, between right to regulate and change in policy that I would say from an expert perspective might violate the regulatory promise or the policy promise made to the investor entering the country, entering the project in the first place? I'm just interested. I know it's a difficult one, but I'm interested in your thoughts on it.
2 minutes.
I can say that in that it is important to have the line of mother and the modern regulation. So in that way, the governments have to put effort on understand how to make policy decision, take policy decision or regulatory decisions. And that's why it is important to put effort on the rules of how to make regulation with flexibility, with transparency, with putting all to listen all the agents, the people, the enterprises, the civil agents of in the country, the investors, everything to understand the policy. So I think it is very difficult to put a line on that because, of course, policymakers or the policy is going, and the regulation is like how do you say it? Like respond to do that. But the way to do that for me is to put a lot of effort in the way that you do regulation. Make effort and that regulation is modern, is flexible, is with transparency, with coherence, and with confidence. So you need to do an that we call impact regulation analysis with all the international advice in order to try to work with that two forces, policy and changes in regulation. I don't know if I was clear. Thank you.
30 seconds. I don't think I have an answer to your question, but I can tell you where I've seen tribunals drawing that line. In recent years, I think when they see some really like gross misconduct by the government, and that's why it's up to counsel. You have to make your case, but like cases where those changes were actually aim at like targeting one specific investor, like a group in circumstances, or when there like some like very specific explicit incentives, like tax incentive of you name it, that were given to a specific investor, where they were taken away without like any notice or like due process. In those cases, I think it's pretty straightforward. When it's a close call is when it gets trickier, and that's when you start getting mixed results.
Well, thank you, everyone. Thank you to the panelists. It was a great panel, and see you for the next session.